pour me low. With their heavy hands and bitter words, they thought they'd steal my show. But I was born in thunder, pain and fire deep inside. Rise back up, a stronger man, no matter how many times they tried. Unbreakable, unshakable, unbreakable, unshakable.
Jerks, how are you doing today? How's everyone doing today? I'm feeling pretty good. We had a good show last night. Had fun with Will Daly. I'm back again this morning. I forgot to tell you last night. Kelsey Fitzsimmons. I'm glad I didn't mention it because I had the timer on. I thought it was an afternoon hearing. It's this morning. It's going to be happening in just a few minutes. We have the stream up. We'll be live. Looks like everybody else in the world is live covering this, which is good. It's when we first started covering it, we were like the first ones. Now everyone in the world is covering it. I hope you watch with us. We always have the best audio. We have it up on full blast. We won't be talking over the court hearing. We're here. We're here, and we're going to watch court today. If you're like me, you were just buying stocks. I've been trading stocks and buying stocks like crazy. Been a wild last 48 hours, last couple weeks actually, last couple days especially with what's going on with Iran. If you're a stock investor, you better check your stocks today. You better reevaluate a little bit. You better trim some positions. You better buy some energy stocks. That's what I'm doing. It's not a recommendation. We never know what's going to happen. But just the way things are looking, I called it a few days ago, and I think I was correct. I've made some big moves in my stock portfolio. Man, this world is on fire right now, I gotta say. But we're in Massachusetts today. I'm sitting in Massachusetts. We're gonna be covering the Kelsey Fitzsimmons hearing today, and we'll be live from court. People are asking me, "Am I gonna be in court today?" No, because I didn't. I screwed up the time. Number one. Number two, my schedule is too busy. I have dogs to walk today. So I'm not going to be able to make it. I'm not going to be able to make it over there to court, but we'll be watching from afar. We'll be watching the court proceedings here, right here in Massachusetts. Maybe like 4 towns over. I'm trying to think how many towns away. 4 or 5 towns away from where Kelsey Fitzsimmons will be today. Lots been happening too on the Kelsey Fitzsimmons front. Some new video came out of Justin apparently bonging it up. I don't care about the cannabis thing, but people are going to make hay of it. And I don't blame Kelsey and her family for doing so because all the shit he's throwing at her, this dude is seems to be breaking the rules of being a firefighter. I don't know if that's allowed. I think it should be allowed, actually, off-duty cannabis use, but it's very controversial. But this is funny that he's now, because he's thrown all this shit at Kelsey Fitzsimmons for months. And this guy lives in a glass house, it seems like. He's got a lot of shit. Like I said, I told people for the longest time on this. He's gonna there's gonna be a lot of shit that comes at him. Yeah, no sound effects during the hearing. No talking. No sound effects. I'm just gonna let it play today. I'm not gonna talk over it. We can discuss after if anything good happens. I'll be watching with you in the chat. But yeah, we try to keep our voices down when the court hearings start up. I think it's annoying. I do watching other shows where they stop it. I don't mind reviewing it afterwards, but when it's live, you want to see what's going on. It's your first chance to figure out what's going on. That's just me. I treat my channel like I'm a viewer. I try to on the channel what I want to see. So no talking over the live stream today when court starts in a few minutes, hopefully. They first it was supposed to be 9:30. Now it's 10. You know how these things go. Sometimes it's a little later too. But last night was a perfect example of what I want to see on my channel. This was the beauty of being called canceled by a group of people is that I get to go back to the drawing board on my show and decide what I want to do based on all my past experiences, most recently, especially. And the big thing is, I want to do a show that I like again, that I'm like into every night, every time we come alive, especially with the guests, but even the content itself. And not that I wasn't into Karen Reed. I was big time into Karen Reed. I still am. I'm still going to cover that. But sometimes it gets just too much. You're just doing the same thing over and over and over again. And it's nice to branch out. Last night was an example of that with Will Daly. It was a long time coming to have a sit down, full interview with Will last night. I made two mistakes. I had two mistakes. First of all, oh my God, I'm so embarrassed. I called this release Boys Are Talking. It's Boys Talking. Boys Talking is the streaming release. And then I played the Eddie Vedder song, and I thought it was gonna be one thing, and it was actually something else. It was actually the song Corduroy, but I didn't mute myself, so that was good. But I think Will enjoyed himself. I know the audience did. And what I liked about it too last night is you could tell a guest is good and the conversation is good when the numbers go up throughout the show. Even though there weren't a huge numbers, the numbers steadily as we logged off, that was the peak viewers of the show. So, and it continued to go up even after the replay. So, I know it was a good show. Good first time guest. He wants to come back on, which is going to be fun, and expect more of that. I'm gonna bring some other musicians on the show. I got a quite a network, and that's what I'm looking forward to. I'm kind of giving myself the space too, to just kind of book what I want when I want, um, on my schedule. I'm not going to be every night. It's going to be once, twice, three times a week. You're going to have something special, like last night with Will Daly. So I want everyone who was watching last night, thank you so much. Give yourself a pat on the back for being there because he enjoyed you as much as he enjoyed being on the show last night. And that was what was great too. He got the whole jerks thing and how great you all are in the chat. The real jerks who are here all the time for me. I love you. So we're just going to keep doing that. There's going to be so much coming up. And if you haven't, please like and subscribe. Kelsey Fitzsimmons, we should talk more about that though, right? I mean, the thing about Kelsey Fitzsimmons is the trial's coming up. It's supposed to be this month, at the end of the month. I can't believe we're in March already, but it's supposed to be this month. We are really close to having a jury trial, and it's just going to be a couple of days, and then it's over. And I think she's going to win this. I really do think she's going to win based on witnesses. I think her witnesses are going to be strong, and I think their witnesses are going to have some issues. The two, primarily being the police officer who shot her, as well as Justin. I think there's going to be some issues that come up, and I think the surveillance video, which I talked about from the very beginning, is going to come into play big time. And when I said that, people were like, they're scratching their heads. They're like, "What's he talking about?" Ever since, what have you seen from the defense? Video after video after video has been released. I've been, like I said, on the inside on this one. I got a lot of sources on this one, and expect fireworks. Expect fireworks. I don't think we're gonna have much fireworks today, but yeah. Jenna Rocco wants to know what town I'm in. Jenna, I will tell you privately. How's that? I will definitely let you know. I'll hit you up later today. I don't like to say online. The trolls are they're relentless, but it's already out there anyways for the most part. But still, just and it's funny though because I always say I wish they would show up. I kind of wish they would because I got video running too, and it'd be nice to see someone get their asses kicked on video, and then the cops show up. That would be great video. They lug you away. I will tell Jenna Rocco though where I'm at. Yeah, I'm always watching, but I'm not worried about it, honestly. I'm not. There's very few people who know how to do the thing, you know? I always say too, like people are like, you should wrestle Sanchez. I'm like, I ain't wrestling anybody that's trained like me. I ain't going up against anyone that can act. Someone's Sanchez got back to me and said, "How about you fight Mike Tyson?" I'm like, "Are you kidding me? That guy's a killer. I don't want any killers. I'm old. I want all the big mouths that have never gotten a fight in their lives. Those are the ones I want. I want all the fishes. When I was a top competitive wrestler, I didn't like wrestling. We called them the fishes. Those are the easy matches when you pin a kid in like 10 seconds. I didn't want the fishes when I was at the top of my game. Today, I'm like, give me the big mouth fishes. It's funny too, because there was always those kids that would try out for the team, come on the team, and they'd say so much shit the week before. The week before they'd be talking. It's the same thing with when you get in fist fights when you're a kid. They talk so much shit, but then as soon as like that first takedown, there's no more shit talking. The shit talking stops. You like my ears? I'm covering my ears. You can't even see them. You like my ears? Are these? You mean these ears? Yeah, that is Nick's wife. That is, unless there's a troll. You never know. There's a lot of fake parody accounts. They troll us all. It's just unbelievable. And Jenna Rocco's on that level where they would definitely troll her. They troll everybody. You know you made it when you have multiple parody accounts dedicated to you. And you find out that they're other YouTubers. It's like, are you shitting me? This is what you're doing. How much do I own you, bro? Just because I made a couple comments. Oh, it's pretty funny. It is funny at this point. I did get mad for a little while. Now I really am enjoying it. I really, especially like knowing what I've been doing the last couple of days with the stock trades and the guests. It's like I am so not focused on the idiots. I just don't even. It's so far from my head now. Their problems are not my problems. My problems are oil and gas and how are we going to eat this year? And I think that in like a month they're going to figure that out too. Not to be doom and gloom people, but this Iran thing is not good. Not good. So we're supposed to be talking about Kelsey Fitzsimmons, but I'm talking about everything else but, of course. So anybody out there do the 401k or the investments, stocks especially? If you do, you better. I'm gonna say it again. I'd be trimming some of the microchip stocks. Make sure you start trimming those and buy some fertilizer stocks. MOS is one. There's some others. Nutrien, CF is another one. I'd buy those one or two, three nutrient stocks because the fertilizer's getting wiped out and the price is going to go through the roof. So you might as well buy it. And oil stocks, gas and oil, buy a Chevron. Easy buy right now. Buy some Chevron or USO, which is US oil. That's the price of oil. I'd buy a little bit. I'm not saying put everything into it, but 10% is a good hedge. I'm up over 10%. I started at like 5-10%, and then I just went crazy yesterday and today and started selling a lot of my big tech gains that I've had for decades. And it killed me to sell some of those stocks. I'm still worried. I might have made too rash of a choice, but man, that's how this whole thing with the oil is. It's gonna affect everything. I think people realize. Yeah, Justin does have custody of the baby, and there's a new filing about it too. They just I should show some documents today, but I'm not sure what I'm supposed to show and not show. So I'm gonna hold them back right now. I'm sure other people have already posted them and shared them, but I just like to be careful. Um, but yeah, there's been some new filings on the family side too, and I'm looking forward to seeing what happens in the next hearings on custody of the baby Caden. Almost not even a baby anymore. How old is the baby now? It's probably, I mean, yeah, it's been a, yeah, that's the worst thing about it. She's been kept from her baby so long. Ridiculous. So yeah, we're just waiting for court to start. Looks like it's about to start now. So I'm going to be dropping off, and I'm going to bring this up. Let's see what's going on in court today.
Folks, everyone, just the elevator's down to the building, so for the public to be able to access this proceeding, we're gonna move everybody down to courtroom 1, which is on the first floor. So I
Oh,
apologize
God.
for the... Wait, 1
It's
minute,
like there's too
hold
many
on.
people there, and they're moving people out of the courtroom. So it's going to be a little while longer.
There's no court monitor here. You'd have to do it yourself. So you'd have to, okay.
I could do it.
Okay. One, oh, here. Morning.
Like they're going to move everyone to a different courtroom because the elevator is broken. They do have stairs, which I did use when I went there. But some people obviously can't use stairs.
I don't think they have a separate computer.
Okay, so we're gonna, everything's gonna be just making an announcement to everyone that because the elevator is not operable and it needs to be ADA compliant, we're gonna move the hearing, this courtroom down to court number 1, which is on the first floor.
All right, folks, we're going to keep on that. We'll keep watching it and see when they come back. It looks like they're going to a different courtroom downstairs, so it's going to take a little while, I'm sure, for everyone to move down there and the cameraman to get set back up down there. God damn, I thought it was going to be an easy morning for me. Now I got to fill in more time. Put up. What do we want to do right now? One moment here. Do I have a good picture of Kelsey? I think I do. I don't like that. That one's a good picture of Kelsey. You can still hear me though, right? It's weird. It doesn't do the side thing. What I wanted. Oh, I know what I need to do. Hold on a second. I'm still here. I'm still here. That's fine. I'm still here. We're just waiting for them to come back to courtroom number 1. Apparently, they had to move down to courtroom number 1. Oh, that would be. You know what? That if they do that, Mink says, "I just pray that they don't remove the child and put him in foster care. That would be heartbreaking. I can't imagine they would do that, especially knowing that they have two good sets of grandparents on Kelsey's side. I don't know what the family on Justin's side's like, but I mean, that would be just so, no, no way. Yeah, I thought it was this afternoon too, but it's this morning. Found out this morning it would be this morning. That's one of the reasons I'm not there. I was gonna actually hope to be there today. I was like, damn, I'm gonna have to rush over there. I was planning on having a busy day trying to get over there after my dog walks. But then when I found out it was early, it was like I can't do it because I by the time I get there, then I'll have to leave to go do dog walks. So I'm just gonna stream it, unfortunately. But yeah, it's this morning. It's supposed to be at 10 a.m. They camera came up, they started up the stream, and then the bailiff, or the court clerk, whoever it was, came in and said, "We're gonna have to move everyone down to courtroom number 1 downstairs because the elevator is broken." So there's some issues in the court, and they're moving everyone down to courtroom number 1. And I'm sure that's going to take some time because they got to let everyone in. They got to put the press in their press section, and then they got to seat everyone else and let the video guy in there and set up the cameras. So it's going to be a little bit. Do I have PayPal? No, I don't. I did have PayPal, but what happened is I got scammed on PayPal. It wasn't even my fault. Somebody just basically stole money out of my account. I don't know how, I don't even know how they did it. They like billed my account. And when I told PayPal, like, I need my money back, this guy scammed me. How is he just taking money out of my account? And PayPal did nothing. I filed one of those, whatever you call it, a fraud alert, and they declined me for protection. So it was like, fuck that. And it was tied directly to my debit card. So it came out of my debit card. I was like, F that. I cancel my PayPal. The only place I've ever gotten scammed, like through a credit card or a payment processor, that didn't back it up. You know what I mean? Any other time it's been through my credit card a few times. The credit card companies always cover you. PayPal didn't cover me. I was like, F that. If that's the way you guys are, yeah, and I'm getting scammed like that, like there wasn't even it'd be one thing if I purchased something and they charged me too much money or something, you know what I mean? Or I was like, I never even used this account. Like the only time I ever used that account was to receive payment from a job I used to work with when I worked for Dig Boston. They used to send me payments that way for writing for them. And so I never used that account except for payments, to accept payments to PayPal, which would then go to my checking account. And yeah, they didn't back it up, so no PayPal. I got Venmo, I got Cash App, and I obviously have you can also become a member on YouTube or send a super chat through YouTube. There's also a membership option on Facebook too. The basement courtroom is bigger. That's good. Yeah. It's one thing if you get hacked on a platform, but it's another thing when they don't back it up. When they're like, "Oh, we're just going to let that scumbag steal $500 from you. We're not going to help you out at all. It's your fault." Trying to think what else we could talk about. Oh, hold on. Looks like we might be getting some signal over there. Looks like something. Here we go. We're back. All right, I'm out of here. I'll see you soon. I'll see you when this is over.
This will be the only and final warning when it comes to the use of your phones. So if you take out your phones or you get a message or anything and you can call or send a text, please do it outside. If you do it in the session, we'll kick you out and you will not be allowed back in. Okay? This is a public hearing. It is a public courtroom. That is until we start violating policy or decorum within the courtroom. Okay, so if you do that, you have discretion.
And you're seeing it right there. Mr. Elaine.
Elaine, that's correct.
Elaine, is that right? Okay. And let me just say, I did have a couple of questions for you folks before I turn it over to you, Mr. Brado.
Sure.
Does the Commonwealth intend to call Mr. Elaine at trial?
Yes.
Okay. And, all right, so I guess a couple of observations, Mr. Grado, then I'll turn it over to you. One is that your affidavit in support doesn't mention Mr. Elaine at all, so I'll just point that out to you. Also, the proposed order doesn't mention him either, or who the subject of the records would be that would be ordered to be produced. And also, essentially, if I understand this correctly, and I did review, there was video footage that you folks dropped off last night, or the end of the day. I couldn't get the other phone back to open, but I did review the video footage. But if I understand, generally speaking, that there's these multiple instances, if I remember correctly, in April or in May of 2025, where Mr. Elaine is observed on this video. I assume that at their residence at the time, smoking marijuana or something.
Yes, Your Honor, that's what we would allege.
And so, and your argument is somehow this would be relevant to Mr. Elaine's ability to perceive the events and hear the events accurately and then convict, relay them. So, but how was, let me ask you this, marijuana is legal, right, in Massachusetts, as is beer. So if the video displayed him, Mr. Elaine, drinking a glass of whiskey or a beer the number of times that you saw him.
What's the difference?
Right. What is the difference?
Happy to answer, Judge. So in this case, the state of the evidence is that we gave you 4 or 5 clips as a representative sample of over 200 clips that we have that are similar over a long period of time. And
in other words, 200 instances.
maybe 270, I'm being a little conservative, but
okay.
over 200, let's say.
All right, over 200 instances of
What you see in the representative sample.
okay, and what was the time period?
So the time period would go back probably a few months, Judge.
A few months before the June 30 incident?
Correct.
Okay,
Correct.
all right. And this is something that has been produced to the Commonwealth?
Yes, we sent them, and actually we got it from the surveillance that the Commonwealth had that they returned to us recently.
Okay.
So they definitely have everything. And so, Judge, it's fair to say that there's a pervasive marijuana use by this guy.
Okay.
And I understand, your point that marijuana is legal in Massachusetts. It's illegal under federal law, number 1. Pages 37 and 38 of the Town of North Andover policy and procedures have a very comprehensive anti-drug policy for all town employees, which my brother and I were just discussing. It's a public document, and it prohibits any drug use on town property, prohibits any showing up to work under the influence of any drugs, no smoking. There's also a statute.
But what's the evidence? I get all this. I certainly understand. And I certainly understand that there's plenty of legal substances, including alcohol and marijuana, that would absolutely affect a person's ability to perceive and recall and et cetera, and testify credibly. But what is the evidence that on June 30th, at whatever time in the morning it was when this incident happened, that Mr. Elaine was under the influence of something at that time?
So, Judge, it was the afternoon, and the idea is that the pervasiveness of the usage raises a legitimate question, and this is a discovery question. We're not talking about an admissibility question at this point. We're just talking about a discovery question. And I would venture to say that the standard there is that is something,
I'm sorry, Steve, I'm
Yes,
sorry, but the case law is clear, is that this can't be, I think it's, I just was reading Commonwealth versus Jones, I think, which is clear that this can't be, Rule 17 can't be used as a discovery tool. It's a tool to make the trial more efficient. In other words, you have to show that the evidence would be admissible,
yes.
right? So,
Well, I mean, it sort of is a discovery tool in the sense that we get the documents early. And in order to get the documents early, we have to make a showing. And I think the showing is made, Judge, in terms of relevancy of his ability to proceed and recollect. That's something that's always relevant. And so we have documented video of him smoking marijuana all over his home all the time for months, over 200 times. And so the pervasiveness of it, I would suggest, points to that there's a problem, number one. Certainly the problem with this guy. But number two, Your Honor, that there's likely to be overlap with his work schedule as a firefighter, where it would certainly come into contravention of town policy, which is page 37, 38 of the town policy, which prohibit showing up to work under the influence of marijuana. And that would trigger the further town policy, which is that if there's an incident, there should be random testing of town employees. And so we think there's a good faith basis to say, give us this early, Your Honor, that if he's been tested at work and he tests positive at work, he's been given breaks at work, he's been put in rehab from work.
But how would that be admissible? So that would, let's assume he, even 2 days before, on the 28th, his screen came back at his employer for positive for THC.
Sure.
Okay, so then what?
So I have a good faith basis to ask him on the stand, you know, were you smoking on when this happened? Do you remember these events accurately? You know, do you even know what you were doing when you were in that basement? Do you know, you're taking your baby under the influence of marijuana?
You don't think you have that good faith basis to ask that question now?
Well, there's always,
200.
I don't need to tell you, Your Honor, trial lawyers are worried about when the guy says no. And that's why it's a discovery matter in terms of, you know, ultimately it would be a discovery matter to get this stuff. But, you know, the lawyer is always at the mercy of someone saying no. And then if you have the backup, you know, we can, as we say, we can prove it up. So it is relevant in that respect of us needing to know how pervasive his marijuana problem is. And we have pretty good evidence, times 200 and whatever, that it's a pretty pervasive problem. And so I think it's probably meets the relevant standard. The lack of fishing expedition, we can't get this material anywhere else. You know, this is something that is important to make sure the cross-examination is appropriate and can be proven up. So I think my good faith basis kind of comes from being able to prove it up. And that's one way I can do that. And you know, I always have in mind, Judge.
But then I'm not sure that the record, again, the balls and strikes that I'm being asked to call in this narrow instance under Rule 17 is keeping in mind that you're asking for me to order production of records, of employment records. And again, I'm not seeing how that has any materiality or relevance to what his state of mind was, Mr. Elaine's state of mind was at the time of this incident.
Well, I think you gave me my answer when, you know, maybe there is something in there just right up against this incident. Maybe he was under monitoring. Maybe he was reprimanded for coming in smelling like marijuana. Maybe he, you know, had some marijuana at the fire department. We have to look at the records. I don't have a magic wand when I say, you know, exactly what they might have, but I can point to relevancy and materiality and lack of fishing expedition by saying we have 200 and something instances of him doing it over a few months. That creates the likelihood that there's some overlap with work. And then, okay, so then we have the town policies, and then there's also another law, Judge, that's Chapter 40, Section 101A. It prohibits hiring of firefighters who smoke for pension purposes. The Commonwealth doesn't want to get into smoke or fire.
But
So-
again, Mr. Brado, all of these statutes that, again, I don't take issue at all with, I asked that rhetorical question to start with, but I don't take issue at all with the notion that marijuana can, and especially something that's smoked off and can affect someone's ability to proceed and then relate what they saw and heard on the stand. It's the idea of getting records that you are fishing for, arguably, no? Because,
So-
hold on.
Okay.
Again, I'm constrained because the case law says that this is not to be used as a discovery tool. Now, let me say this. I've been there before, and I know that you're between a rock and a hard place because you have some information, like you do, about the possibility that they'll be in the records, but the SJC has made it clear that you need more, I believe.
So you're the judge, and I respect your ruling, but I should just say,
Well,
Judge,
I haven't ruled yet. So
I
don't expect anything
I
yet.
appreciate it. My thought is that whole business about it not being a fishing expedition, I think that what they mean there is that you can't be held, the defense can't be held to the standard of knowing what the other people have without getting to it. It would be easy if we could say, I know they have 16 reports from 16 days that he showed up smelling like marijuana and stumbling around. But, that's never the case because this is adversarial litigation. And so we don't know, and we never do know. So the courts can't put the defense in this catch-22. We have to ask for the records, and it can't be a situation where, you have a time machine, you have a magic wand, whatever you want to call it. We don't know. Defense counsels never know. And that it can't mean that Rule 17 means nothing. So you have to interpret this fishing expedition thing as meaning just completely throwing darts. And so what I'd answer to say why we don't have a fishing expedition here is because, excuse me, we have this incredible number of video documentation. And we know that he's a full-time firefighter in the town. And so the likelihood of an overlap is pretty substantial. So that's really all we have. And that's all a defense counsel can ever have, is kind of skirting around the edges.
And in fact, arguably, you have more than we often see, right?
I think so, Judge. So, this is just, this is asking for records that will potentially be able to give me the ability to prove up a denial, I think, if you will. And, who knows what he's going to say? I don't know, because he's an adversary. So, I'm just trying to get the record as populated as possible. And if I have information, I'll know the parameters of what he's saying is truthful and what is not truthful. And I think it would make for a better cross-examination and a more economic cross-examination if I'm not dancing all around without the benefit of these records. So that would be my argument, Judge. Thank you.
Pablo?
Well, I think I just echo much of what you said, and so I hate to do that, and echo what he said. He said, maybe, we don't know. That's the definition of a fishing expedition. That's the definition of a discovery tool that that's what he's looking for, and he well admitted it. He has a basis to ask that question. He could ask the witness on the stand, were you under the influence, or had you smoked, or anything like that. He has a good faith basis to do that. I wouldn't object to that question. I think it's a fair question based on the landscape that we have here. And the answer is what the answer is. And that's often the case. So I would suggest to you, he has not met his burden, and the court should deny the motion.
Mr. Brady, anything else?
No, Your Honor, thank you.
No, on that.
No, that's all I have for that, yes.
So I'm going to issue a more formal ruling later, but the motion is denied because the defendant has not met her threshold requirement under the Land Pond Protocol. And as I said, I'll be more specific in my written ruling later. All right, now that moves us to dispatch. So, I thought we would then go to the defendant's motion in limine, which has various requests. Let me just get in front of me, paper 67. Now, I meant to point this out even before we started on the Rule 17 motions, but I think it's worth saying. So, Mr. Gubitosi, at the last hearing, you said this is something to the effect, probably more eloquently than I can remember, but something to the effect of that this is a very simple case, straightforward about what happened in the bedroom. And I'm glad to see that the defense seems to agree, because in in this particular motion, Mr. Gradle, you wrote, the narrow issue here is whether Ms. Fitzsimmons committed an assault with a dangerous weapon against Patrick Noonan on June 30, 2025 in the bedroom, et cetera, et cetera. So I point out that you folks agree. So that's my thinking here in trying to keep things simple when I'm addressing all of your motions and your trial motions and your requests. I agree that we at least have an agreement on a starting place. But let me hear you, let me ask the Commonwealth on the defendant's motion. So, as for sequestration, let me say this. I typically don't issue sequestration orders formally. In other words, I would, and I'll ask the Commonwealth, I would just rely on if there's an order in place for you folks, both sides, to tell your witnesses that how it works. So does the Commonwealth object to a reciprocal sequestration? In other words, yes? Okay. Thank you. So I'm going to allow the request that the trial witnesses be sequestered as that term is used in your motion, and it will apply to both sides. So I would, you'll be responsible in conveying to your witnesses that particular order, that they're not going to discuss their testimony with other witnesses. All right, and on number 2, the opinion terms. So I almost always use people's names, their surname. It's very possible, if not probable, that I would use a term like alleged victim, who I believe would theoretically be, not theoretically, would be Officer Noonan. Thoughts?
The Commonwealth has no objection to number 2, so long as it also is binding on defense counsel.
Meaning what?
He also not refer to anyone as victim, suspect, target.
Right. So are both sides okay with alleged victim?
Yes.
Of course, yes.
Okay. All right. So I'll allow that, and I'll write this up later so that we're not. And number 3 is basically a motion to preclude prior bad acts or other acts. And let me say this: it probably makes sense to hold off on this because I view this as an opposition to a couple of the Commonwealth's motions, I think. So just remind me, Mr. Brady, and we can circle back if I haven't addressed everything.
Certainly.
In there, number 4 is voir dire. Let me hold off on that for a moment because the Commonwealth also has voir dire, proposed voir dire. But let's go to number 5, which is the last. So number 5 is that the court exclude. There's a lot there. Commonwealth.
I mean, I think most of it is not really applicable to the facts of this case. So insofar as, the defendant is known to other members of the North Andover Police Department because she was a North Andover police officer, I think that's kind of unavoidable. They're
But not a
literally-
repeat offender, that's what I'm,
certainly not repeat offender. And I think the defendant never fled anywhere. She was never a target of any, broader investigation. So I think as this is somewhat boilerplate, it doesn't really apply to the case, so there's no objection.
all right, so that'll be marked as allowed of objection. And we really should at some point talk about, and this may arise during the hearing on one of your Commonwealth's motions, but talk about the scope of what the evidence will be as it relates to this 209A work, right? And I think we need to flesh that out, or maybe it doesn't need to be fleshed out, but we'll get to that in a moment. So that leaves paragraph 4 in the defendant's motion, which is request for a voir dire. And while I'm addressing the defendant's request for voir dire questions of jurors, let me get the Commonwealth's out. Paper 63 is the Commonwealth's request for jury questions. So let's just go back for a moment. As I said, I intend to handle this impanelment like I do all impanelments, and that is to use a case-specific juror questionnaire in addition to the single-page questionnaire that the jury commissioner issues with the summons. So my philosophy is, and also you folks will have, we will conduct individual voir dire of every juror, whether they answer yes to any of the questions or not. You folks will have permission to ask reasonable questions as part of attorney-conducted voir dire. My philosophy is to put as much of the questions you folks think are relevant in the questionnaire, so that it just will speed up the process. Obviously, you'll have your own things that you'll want to maybe ask personally, which means that the questions have to be formulated in a yes or no, in a manner that calls for a yes or no answer. So when I look at the defendant's request, I mean, I definitely can include something like A and B, C, mental health issues in general, and yeah, D will be in there, E will be in there. Yeah, F I don't ask. I'm not saying that you can't, but same thing with G. I mean, there's obviously versions of F and G when they're asked whether they can obey the idea of the presumption of innocence and reasonable doubt, etc. But same thing with H and I and J. So all of those things are kind of covered, but you'll be free to ask follow-up questions or questions that pertain to that. Now, so on the K, I'll formulate something. Does it make sense to have some kind of question related to groups such as, I don't know if this is still pertinent, this is from years ago, fathers' rights groups, groups that may advocate for Second Amendment issues. I don't know, things of that nature. They could be grouped together, but I think K is just too broad. So I'd be amenable to, again, asking for, if they've ever, if a potential juror has ever donated to or volunteered for a domestic violence related organization, or if that's what folks think, or some kind of a parenting shared parenting organization related to that.
Yes, I think we should do something like that. I trust your judgment to formulate that.
Same.
Okay, so on the Commonwealth's and paper 63, I think I cover almost all of this, at least on the first page, second page. So it does make sense to ask about, as the defense requested, suicide, mental health, in general, postpartum, even. I can formulate some questions related to that. Training and experience with mental health issues. I don't know, is mental health going to be a issue? Well, it's going to come up at some point, right? Even on a limited basis.
I think it's going to be very tangential. I think it's really more about, and actually my brother and I just hatched out an agreement that the way that this was served, as they all are, is without an affidavit. It was just served, the order was served. And I think we have a stipulation that we can just admit what was served, the restraining order. And the terms of the restraining order are what we both, literally we just discussed this, what we both are interested in utilizing. So I think that will probably cover the issues that we both are concerned about without opening too many doors on either side.
So I guess the question is, do you think I should stay away from 8, 9, and 10, and 11? Or do you, that being on the Commonwealth's request, or do you think that those things are worth asking about?
So I have an objection to 8, 9, and 10 because I think it's kind of suggesting things that aren't going to come up. You know, mental health disorders, I don't think that's really going to be something that's going to be discussed at this trial or ought to be
But
discussed.
you've asked, but you folks are asking about suicide, so wouldn't that beg the question? No? I mean, obviously there's many reasons that people commit suicide.
Not necessarily, you know, I don't want to invite some sort of wide-ranging exploration of, you know, Ms. Fitzsimmons' medical history. And not to suggest there really is anything that's, you know, awful. I mean, we have postpartum depression. Whether that becomes an issue in this case, I don't expect so. I think she was served with an order that did 4 incredible things to her life and would do 4 incredible things to anybody's psyche. She lost her 4-month-old child completely out of the blue. She's home with her baby in sweatpants having fun. She loses her 4-month-old child. She's betrayed by her fiance. Her marriage is over, ain't gonna happen necessarily, and you can picture her sort of almost having this realization. Her job's over, her guns are gone. Again, she just got them back. There was a 100-page report clearing her of anything and putting her back at work. She was going on the schedule in 3 to 4 days. And the other thing is that she was completely humiliated in front of her own work friends and colleagues. So I don't think we need to really go to dig up any sort of diagnoses, especially something as common and, you know, expected in a woman as postpartum depression as a reason for wanting to just end it all in a brief, half-hearted minute.
Okay. So the bottom line is you object, the defendant objects to 8, 9, 10. How about 11? Just the training related to mental health.
That one, we're okay with that.
All right, so 8 to 10. So let's just take them a bit at a time. Commonwealth, from your perspective as to 8, 9, and 10.
Obviously, we cannot predict how the trial is going to proceed. However, based on counsel's representations here and prior public representations, it seems like the defense is going to be that, based on the confluence of those 4 factors, the defendant claims that she was attempting a suicide attempt. I don't know how you divorce suicide from mental health issues. I think that the two are one and the same. When someone hears suicide, particularly in a jury pool, they're going to think mental health. I think it's going to come up that why did Justin have it, it's not guaranteed to come up, but the fact of the 209A order suggests that there was a reason why a neutral magistrate determined that Mr. Alien should have custody of the child. So I think mental health is an integral part of the case. The Commonwealth is not shying away from that. I think that we need to ask the jury about it because depending on how this trial goes, it could be very narrow, it could be a one-day long trial. It could be much longer depending on how things go. So I think we need to really probe the jury and find out what any biases that they may or may not have with respect to mental health in general.
Okay, mental health is an easier concept broadly because it's been raised somewhat by the suicide request by the defendant. But as for the specifics related to postpartum, so does the Commonwealth believe just in your case in chief that would somehow come out?
No, but I mean, there are signs outside talking about postpartum depression is not a crime. So it would be.
And at the end, how come I remember? I'm surprised that this, Mr. Grado, the postpartum depression is controversial from the defendant's end because I thought I read in some submission somewhere that was a fact from your perspective, right?
So as we're evolving kind of towards trial, Your Honor, it occurs to me that the case is really doesn't matter much about why the person got an order, what was going on with these people. The police are serving an order. That's their legal duty. It doesn't matter what the order says or how it was gotten or whether it's based on truthful information or fraudulent information. They have a duty to serve an order.
Okay, but let me ask you. Tell me the facts about the service, the actual service of the order, and that is that. Does the Commonwealth believe that the evidence will be that the defendant read the order and understood it before, in other words, processed it somehow and before the shooting? Yes,
okay. You processed the order, not the affidavit.
Because the affidavit wasn't there. All right. So Mr. Grado, presumably, and you said this, is that your client's state of mind is significant, right? Because she has to have intent, right? And there was some mention in some filings about perhaps she was pointing the gun at herself. You asked about the suicide attempt. So I'm failing to see how just asking a question about postpartum depression somehow prejudices the defendant.
My
I'm
thought
not
is
suggesting that it would be admissible or not, but it's just a question.
right. I mean, I'm concerned about the degree of disclosure, and I feel like the second it gets mentioned that the government's going to allege that we've opened the door to something, and that all of her prior incidents are relevant, and now they have to come in about postpartum depression. So, where I have an order that did those things that I just recited a few minutes ago, I don't really think that, we don't need to gild the lily here on, and on top of that, she has a bit of postpartum depression. How far do I have to go? Those things that I said are eye-popping. To have that happen to anybody out of the blue on a nice summer day when you're home with your baby.
Especially if they're suffering from mental health
I agree.
or conditions.
I agree, but I don't want to open the door. And if
You're not. So let's be clear.
Okay.
We still need to drill down on, at least I think we do, on what is admissible broadly in this area. All I'm addressing right now is the simple yes or no question related to postpartum depression. And that is whether they have any experience. I could use something similar to Ms. Moriarty. Were you Brito in the Brito case? Where there was a significant mental health issue or issues, and it would just be yes or no. It's not. I would never say there'll be evidence that the defendant. It's just your experience with it.
you're giving me a comfort level, Judge, and I'm okay.
Okay, but the other thing too is just understand this: is that I'm gonna take the information that we gleaned, that we discussed now, put it in a draft of a questionnaire that we'll go over before it's disseminated, and you'll have an opportunity to see exactly what it is I'm asking. I was hoping that would be today, before they're disseminated. Before I forget, while we're talking about, so give me an opportunity
Okay,
to put that in there.
I'm okay with it,
And
just
just
give me a comfort level, Jeff. I'm okay.
You don't need to be comfortable. All you have to be comfortable is that it's going to be in the draft, and you'll have an opportunity to see exactly what I'm
Thank you.
going to ask. And that's for all of these questions. But can I hate to float around, but one of the issues I have is related to the draft of the juror questionnaire. Is I think that there's obviously media attention to this case, there's public attention. The public and the media have a right to and the defendant to a public and fair trial. I'm concerned about having a draft of the juror questionnaire getting out there by mistake or et cetera. So I'd be inclined to simply impound it, disseminate it for your eyes only, for, obviously to provide, show to your client, and just impound it until we get to, and then we can talk about what we do with the final one as well. But any objection to that from either side?
No, I think it's a great idea.
Okay.
Okay, all right, so that's the way Mr. Ruling, just have to remember that's the way we'll handle that. All right, so I think that, does that cover everything? I think firearms related questions and Second Amendment type of stuff that I typically ask in a firearm possession case would be pertinent. Again, why don't you folks just with an open mind take a look at what I write, what I draft, and you can object or take it out. Let me just look at the rest of this. Yeah, all of the rest of the questions would be included.
Your Honor, if I may add one that was not written.
Sure.
If you are going to reference, at least how defense counsel has it phrased, there may be references to suicide attempt. I think that is a way that gets the jury comfortable with the defendant's theory of the case. The Commonwealth would ask if that's the way it's phrased, that.
No, I'm shaking my head because it's not going, it won't be phrased like that. At least initially when I drafted it, I think that all of these questions have to be neutral. They have to be neutral to both sides, in fairness. But more importantly, again, it's not. I don't like asking questions that are case specific. The evidence may show because it may not. So the issue is whether they have a personal experience with suicide. All right. Again, from the defense perspective, and that's what they'll be asked, something like that.
I would just like to raise the point of suicide suggests that the person committed a violent act themselves. The Commonwealth, one of the Commonwealth theories may be that it was an intended suicide by cop. So that.
Oh, okay.
So I just think that if Your Honor can consider that when drafting your jury questions.
Oh, so in other words, you'd like to perhaps a question that would cover so-called suicide by cop?
Yes, Your Honor.
All right, so
Thank you.
just, I'm not sure that I'm that creative. I'll have the ability to artfully draft something like that, but we'll put a placeholder in there. I'll do the best I can, and then you folks will.
Just to chime in on that,
Sure.
I'm not crazy about that because it's too specific, too suggestive, and it just adopts the Commonwealth theories. So I think the topical reference should be where it begins and ends. Just put in my position.
Okay. So it seems to me that they're going to be asked, like in any serious case, whether they or a person close to them have been a victim of a violent crime. So typically I ask that, maybe, or been accused of perpetrating a violent crime. maybe it needs to be shooting related, that question, or firearm related or something. But again, I'll draft a few questions that I think are appropriate. You folks will weigh in and we'll hammer them out. Anything else, just generally on voir dire, on the juror questionnaire?
No.
And then, all right, what else did I want to say about? I have to tell you, from my perspective, you folks tell me you know your case better than I do. I think that the impanelment will take 2 to 3 times as long as the trial. I'd really urge you folks from taking a look you probably have at the rules of professional conduct as it relate to trial publicity, and just do your best to make sure that we can get from the start a pool of potential jurors that are indifferent to the extent that we're able to. But I hope I'm wrong, but I really think that the impanelment will get 14. I don't know. Anyone disagree?
I think that just depends on what he potentially opens the door to. About how long the trial will be.
Okay, I'm not really understanding that, but I'm not sure that I need to. So let me talk a little bit about scheduling. So I'm going to assume that we start handling on the 23rd. We get jurors here in Lawrence on Monday, Tuesday, Wednesday, Thursday. We get the most jurors on Monday, and then the amount that we get are less than each day. I think that we should assume that it will take through Thursday, and that the trial, I should tell the jurors, perhaps even in the questionnaire, that the trial would start on Friday or even the following Monday. And then you tell
We
me.
can think about that only because we only get 6 challenges each. So that sometimes makes a difference. I understand other challenges that we will be dealing with, obviously, as far as people knowing about the case and reading about the case and the like. But
I'm glad you raised the number of challenges, because I got to get my water from you, because the last handful of trials I've been like felonies, where folks get more. But my memory is that on the criminal side, you get 4 and 1 extra if there's going to be any extra seated jurors. Frankly, whatever the rule says, I'm going to give you. I know the council oftentimes tell me, well, in Essex County, judges typically do X amount. I don't care. Whatever the rule is, and I don't have it in front of me, I think it's 5.
But we were just talking, I thought it was 4 and then a challenge for each extra juror.
Of course.
Each alternate juror. So
All right. I don't have my, but whatever we'll all research.
I agree with that, Judge. And then if there are 2 alternates, we get 2 more, so there's, typically 6.
I don't think that's.
Whatever you want.
I don't think the rule. I think the rule is for any that are over and above the 12, you get 1 more when it's not a light felony. But again, it will be 5 or 6. We'll figure that out. I need to tell the jurors the start date, and I also need to tell the jurors an expected end date for them to get that, when they'll get the case. So what I was going to propose is that they be told that the trial would start again on the actual trial, the evidence would start on that Friday or even the following Monday, and that they would get the case by the following Friday, April 3rd, which is over estimating the length of the trial on purpose, so that we have built in time.
Sure, I think we don't want someone going away, I totally agree with you. I don't know if it's gonna take, that many days, maybe I'm being naive, to find a jury.
Okay.
So, but we can, maybe we see where it goes. I mean, I think maybe we say we start on Thursday, and you give up a day. And
Okay,
go from there.
yeah, we can even, tell them that we'll start on Wednesday or something, you know, and see, I'm surprised, and, all right, but don't be surprised when you get a draft of the, juror questionnaire, that it says that, you know, I estimate that the jury will get the case to begin their deliberations. I'm just gonna probably just default to April 3rd, which is Friday, because then in the next sentence, I'll say that thus you know, therefore you should be available to serve the following week, in case it lasts longer. All right, so let's talk about, and this we have more motions which we'll address, and this may be the subject of, let's talk, from the Commonwealth's perspective, I'm trying to get a handle on what exactly the evidence will be related to the purpose of the police being there, how much you expect to get in during your case in chief about this custody issue that was ordered, etc.
Well, the underlying facts that I expect to come out is that a restraining order was sought. Mr. Alien was at the PD. He gave the restraining order to the officers. 3 officers went over to the house. He stayed back until they called him to come get the child. They called him. He went. Was in the process of gathering things. The officers went upstairs after serving the restraining order and explaining what was happening to the defendant. The shooting occurred. The end. So I don't anticipate getting into more than, or the jury really hearing more than that in the Commonwealth's case in chief.
Okay.
Subject to any of the motions that we have filed.
So maybe it makes sense to, let's start with paper 61 because this kind of segues into that. And that is the Commonwealth's motion to eliminate to prohibit questioning regarding custody status. And actually, when you say custody status, you mean both the child custody and the pretrial detention aspect.
I do actually.
Okay. All right. So let me first, before I hear from you, Ms. Morelli, is there an objection to either one of these items in paper 61?
We don't expect to be employing anything down that road about custody.
About either custody, about the custody issue related to the child, and about your client's
Well,
detention?
only to the extent of the contents of the order that's being put in front of her, and that to the extent that it's just an obvious part of the whole thing is that
Right.
you know she's packing a bag for her baby, she's giving the baby to the police to give to the father. Just what's in the order. I think we're probably in good shape on that in the sense that we're both agreeing we're going to stipulate to the order. I think just as an exhibit, and the order says what it says, and we're going to both use what it says on the order.
Okay.
So I think that's the extent. That's the extent that I.
All right. So obviously, you can argue and question witnesses based on reasonable inferences from the order, but doesn't the order mention custody, temporary custody? Do you folks have is there a copy of the order? And I thought I saw it in the file.
So I think just the custody post June 30th, 2025. So insofar as the child is still with Mr. Alain, I don't see how that's relevant. That was really so the fact of the fact, we're not disputing the fact of the matter is the 209A order granted Mr. Alain custody of the child that day. We just didn't want there to be additional on direct or cross of any witness, you know, the current custody status of the child.
Okay. I can't imagine you want that.
We don't.
Okay. All right, so, and then do you anticipate, Mr. Gradle, that you would raise your client's pretrial detention status?
Yeah.
All right, so then it seems to me that I can allow you without objection, as it is narrowly tailored. All right, so, so then that brings us to paper 62. Commonwealth's motion in limine to preclude questioning regarding current duty status. So let me be more specific. My understanding is that you're seeking, Commonwealth is seeking to preclude evidence regarding the Officer Newton's now current status with the North Andover Police Department?
Yes, sir.
Okay. And what is the status?
The Commonwealth's understanding is that he is on leave.
All right, so you would want to preclude any mention about that Officer Newton is on leave?
Yes.
Okay. What do you say, Mr. Prado?
Judge, I think that we're just talking here about perhaps putting this in abeyance until we get the IAD files, because we have a lot of information that I think we have more information than the Commonwealth, frankly, about his status, that it may direct this debate in a better way.
Yeah, maybe I just defer ruling.
I think that makes sense, and we can address all the issues kind of
Okay.
simultaneously.
Okay. So that brings us to paper 64, defendant, Commonwealth's motion in limine to admit prior bad acts if they become relevant. There's also some good acts on another motion, but go ahead.
With respect to the prior bad acts evidence, Your Honor, as captioned, the Commonwealth recognizes that those are not relevant to the Commonwealth's case in chief. However, in abundance of caution, the Commonwealth wanted to alert the court to evidence it had in its possession about prior bad acts in case they do become relevant based on opening, cross, or the defendant's case. So we can really hold those aside for now, but the Commonwealth just wanted to alert the court, and obviously, if the Commonwealth believed that a door was open, we would come up to sidebar before any questioning related to any of these issues.
Okay, so, and I appreciate that you're being careful. So the bottom line is you're not seeking, the Commonwealth is not seeking at this moment to admit other acts, but you may argue, as either side would argue during the course of the trial, if it arises that the door has been opened, and we'll have to address it at that time.
Yes, sir.
All right, so I'm not going to take any action
That's
on
fine.
it. No,
Yeah.
that's easy. It will be deferred until is necessary, which brings us to paper 65. This is Commonwealth's motion in limine to preclude questioning regarding promises, rewards, or inducements. And I'll hear you, Commonwealth, on that.
And this is a subject that we touched on last time.
Right.
Just concerning the request for a promise, reward, or inducement. And so I think we're kind of in a slippery slope, because if the council is able to ask the witness concerning post-event accusations, because these accusations that the defendant has made in unsworn statements and the like is going to muddy the waters. One thing that the
But which accusations are you talking about? The accusations related to Mr. Elaine allegedly breaking into the house, or the accusations about purported favorable treatment of Officer remind me.
I'm sorry, this is the alleged breaking and entering. Okay? Because it is post what we're talking about here, the Commonwealth has stated on the record, we're not pursuing that, and we're not pursuing that, it's based on our prosecutorial discretion, but honestly, with our prosecutorial ethics. These are allegations that were made by the defendant in unsworn statements that the Commonwealth believes many of them are just false. Mr. Alain was a resident of that home.
All right, hold on.
Yep.
I'm hoping that we don't have to relitigate or even litigate for the first time the alleged conduct. The bottom line is the Commonwealth is seeking to preclude mention, Mr. Gradle, of the events of this breaking and entering. Okay, and do you object to that?
So I don't expect this trial to go down this side road. But to the extent, I don't think Elaine really is a relevant witness in the case. Granted, he's on the premises, but he has marginal relevance. And I think that
It's kind of, that's what Mr. Gubitosi said at the last hearing, but you didn't seem to agree. So maybe you rethought it.
he's a dangerous witness, I think, from both sides. Let's put it that way. And so it's a complicated scenario, Your Honor, that, if he does testify, that opens cross-examination. That might open some other doors too. But, I mean, if it was me, I don't think I would call Mr. Lane because it opens up all kinds of cans of worms, and he has testimony that's only duplicative of other people. And, the fact that he's there on the premises, let's put that aside for a minute, that they let the guy who gets an order to have someone stay away from him, they bring him to that premises. Let's put that aside for a second. But he's like a straw man. There's nothing that he adds to the trial, and I'm going to cross-examine him, but I don't want to open up certain doors. So he's a very complicated witness. He's one of those kind of mistrial witnesses. So I don't know why they're calling him, frankly. But if they could, this is, I guess, my position. If they call him, then all bets are off.
So I can't imagine that you're asking me to preclude the Commonwealth from calling
No,
witness.
not at all.
The Commonwealth has a burden of proof, and they're going to, within the rules of law and evidence, though, they're entitled to try to prove their case, just as Ms. Fitzsimmons is. The issue is, do you intend to ask Mr. Alain, if he testifies, isn't it true, Mr. Alain, that on such and such July, whatever date, you busted down Ms. Fitzsimmons' door, went in and, stole things and et cetera?
Yes.
Okay, we intend to ask that. And that's, again, understanding that some of this depends on what he says during direct, and I totally get that.
Yes.
But just from a 10,000-foot view, how is it relevant?
So he's getting special treatment from the government, Your Honor, and he's been coddled and protected by the government from before the service of this order. There's all sorts, and talk about opening doors.
But why using your theory where he's this background witness, why would the Commonwealth be motivated to do that? And when I say the Commonwealth, the Essex District Attorney's Office be motivated to give him special treatment?
He's in with the right people, Your Honor. We would be able to prove that he's in with the right people. I don't want to give you too much, but I hope you're satisfied with the direction that would go at this point. And he's in with the right people. They knew this was coming. Ms. Fitzsimmons was at the police station the morning of this event, being treated fine. Brought the baby to the police station, took a CPR class to refresh for her upcoming appearance on duty schedule. She was treated wonderfully. She saw her friends. She did the training, she passed the training, she had the baby there, people are taking pictures with her. At the time, police administrative officials knew what Justin was doing that day. They knew he was going to do this. We have information, Your Honor, that when one of the gentlemen in the department said, "Oh wait, we got to give Kelsey her radio for July 4th." One of the administrative people said, "Oh no, just hold off on that. You don't know everything that's going on right now." They knew they were conspiring, to use the appropriate word. They were conspiring with Elaine before this service for this whole thing. And there's an entirely
They
other
were conspiring, oh, I thought.
with
you said-
Elaine too.
I thought you said Elaine.
Yeah, I'm sorry, with Justin Elaine. They were conspiring with him that he was going to go get this order, he was going to communicate with them, they're going to serve this order, and, you know, not to put too fine a point on it, but there were many people in that department that didn't want Ms. Fitzsimmons to go back to work. And this served the police department's ends as well, to blow her up by serving this order in a certain way. So you see where I'm going, there's a lot of doors here, Judge. There's a lot of doors.
The doors are easy from my perspective, because it's about the rules of admissibility of evidence. So, it seems to me that, again, the narrow issue here is whether you get to cross Mr. Elaine on the fact that these facts related to his alleged breaking and entering, and from my perspective, it would only be relevant when you say special treatment is if somehow he's changed his story, right? So maybe some of this we'll have to hear his direct, but there would have to be some basis to cross him on it that he's somehow trying to curry favor by changing his story.
I think it also tends to explain the unorthodox manner of service of the order, Your Honor, in the sense that they let him go into the house. Okay, he's an adversarial litigant against the owner of that house. He just got an order against her. Keep her away from me, I'm scared of her. The police let him into her home. So there's all kinds of bias. There's all kinds of special treatment. You know,
I have to say this from my perspective again. That either reading or listening, reading the transcripts of these calls that Mr. Elaine was making to the North Andover Police Department, I can't. To say that he was in with the right people, maybe he was on one date, but he was pretty pissed off on the date he was calling and wanted
because
to
he
take
wasn't
credit.
used to getting this special treatment he always gotten. And it fits the story entirely.
Because during those calls, he's saying that repeatedly that he's going to take it to a higher level. Meaning, I think somebody even asked him, "What do you mean by that?" And he said, "Talking to the chief or something," and how he was complaining that the North Andover police failed to protect him. All right, so I'm not sure when you hear from the Commonwealth. I'm not sure.
A lot of that is just the tip of the iceberg, Your Honor.
I'm not sure that I can rule on this right now. You can tell what my present thinking is.
Sure, and I agree with that. I agree. He made a statement. His testimony is going to be unless the defendant opens the door, very limited as to the presentation I made a little earlier. If his testimony changes significantly because of that, then it may open up to something different. But having said that, the Commonwealth decided not to prosecute. We're not promising anything. We decided not to prosecute for specific reasons because we believe there isn't a basis to do that, a good faith basis to do that. I can't reiterate that enough, but having said that, what does any of this have to do as to what happened in the room up there? Because if counsel is up here 1 minute saying it should be very narrow, very short case about what happened in that room between Patrick Noonan and the defendant, and then all of a sudden wants to litigate a different case about the corruption of the North Andover Police Department, Mr. Ayalian's favorable treatment. Well, you know, you can't have it both ways. It's either one or the other. And so that's what I'm a little nervous about now, is that, okay, we start this trial one way, and the representations have been made, and now we're taking it to a different place. And that's why the Commonwealth has filed that motion previously.
Okay, so here's the thing. I think where I come out is I have to defer ruling until I hear the direct, or if the Commonwealth were to otherwise open the door. So what I would say is just come to sidebar before you ask those questions, and because I don't, generally speaking, I express my view of it, but it wouldn't be fair of me to Ms. Simmons to completely preclude it without hearing the director any of the cases. So that's my ruling. It will be deferred until.
Sure.
Yeah, sure.
Can I just say, just in response to what my brother said, I was actually going to use that against him, that they can't have it both ways. If you're going to call the witness, I get to cross-examine him.
I want to use that's why I tried to start the hearing with the agreement that I saw. That is that Mr. Gubitosi saying it was a simple case, Mr. Bradle saying the narrow issue here is it's a simple case, and I want to hold both sides to it. So,
I agree, and I just have a concern about opening doors, and I just want to, I agree that it should be a simple case. I hope it's going to be a simple case. It should be a simple case. We're even thinking about making it simpler, and, you know, I know we still have to deal with all this jury stuff. You know, we talked about a possible bench trial. I don't know yet. I'm just saying, everything's on the table still. But, you know, if they're going to call too many witnesses, I got to cross-examine too many witnesses. So, you know, it depends on where they're going to go with him. And, you know, he's going to have his comeuppance in family court. And I don't think I really want to get into it too much here. And if the Commonwealth wants to call him, it's going to happen, to the extent you know our lesson. Thank you.
okay, all right. So I'm going to, on paper 65, I'm going to defer ruling until trial, really until after Mr. Alain testifies, and the defense should come to sidebar before asking questions related to that. Let me ask on something that Mr. Brado just that I wanted to ask, but let's just march. I think we have one more motion. Commonwealth's motion to admit prior good acts. Yes.
Again, I think this would come up more in redirect than in direct of Patrick Newman. So I would just ask to alert the court that this exists, and if we feel it becomes relevant, on the sidebar prior to redirect.
Okay. So I'm going to defer on that as well. And let's just talk just generally. Do you folks, are there any exhibits that you folks think are going to be the subject of strenuous objections in litigation? And if there are, if you can just, let's just get out in front of them. All right. I'm sorry, something that Mr. Brado just raised, I wanted to follow up on it. I just can't recall it. We'll come to it. All right, so what that leaves is paper 73, which is, just get it. That was filed this morning and the motion to modify the pre-trial conditions. All right, so it's paper 73, defendant's request for change of address. All right, so let's just make sure that we're on the same page, Mr. Brado. And that is that you're seeking, there is an order in place now that the defendant reside at a particular address in Bethune,
Yes, sir.
With Lauren and William Page. So you're seeking what, to?
So Judge,
Yeah.
can we put a sidebar on some of these issues, Judge?
Sure, absolutely. And if we're going to do that, Ms. Fitzsimmons is going to come up as well.
Thank you very much.
Sidebar. Oh, damn, this hearing's lasted a long time. I wanted to step out to walk some dogs, but I also want to play some other video after this hearing ends. There's some things going outside the courtroom I want to take a look at today. God damn, my day might be too busy. I don't know. I might have to do a part 2 today. How long the sidebar's gonna last? Walk the dogs. We'll wait it out. I'm tempted to go to the other video for a minute. I always rewind it. Something happened before court today. Let's watch and see what happened. I have no idea what happened today. I want to see this while we're waiting in sidebar.
What up, my brother? Good morning.
Good morning. Good
JFK
morning.
show off.
We are live.
We are live.
We're at Lawrence today, hanging out in Lawrence.
Couple
Hello,
people just
Lawrence.
went in.
What can you tell us about Lawrence, Jay, bro?
So it's a pretty rough city to grow up in, but it's a city right now where I'm waiting for someone to show up at.
Oh, really?
Oh yeah,
Nice.
that's him. That's him?
Back.
Because we were at sidebar. The Commonwealth objects, this would mean changing the condition to basically 2 conditions. One is to reside at a particular location in Methuen, and second, to reside with Mr. and Mrs. Page. As far as I can see, those are the 2 conditions that this would impact. And Commonwealth objects to both. Does Commonwealth object to both, or to one, or to all both?
Well, there was a long hearing and a long history to this case. And one of the conditions that the defendant was placed under was that she would specifically live, I don't care what house it is, but with her family, with her mother and her stepfather. There was a colloquy with her mom that she would take custody of her, and that she would oversee what she was doing, and that she would report to probation if there were any problems. Now she's asking to live on her own, which I think is a marked change to what we've been doing for the past few months. She, in her affidavit, it's basically.
Well, so in fairness, all I wanted was a yes or no. No, that's fine. Because I want to give Mr. Grady an opportunity to argue this motion before you. I just wanted to make sure that there is, so it seems like you oppose both, or is it more the supervisory role of the parents?
Well, which resident, if they could move the entire the family to another house, I don't care about that.
Okay.
You know, as long as probation's fine with it.
So, Mr. Grady, I'll have
Yes, Your Honor. Thank you very much. So, Your Honor, Ms. Fitzsimmons is a 28-year-old adult. She had this order at a different time in the case. And, I'm not going to get into too much, okay, but this order was entered in very suspect circumstances. And I know what you're going to say, Judge, I'm sorry.
No, it's just not helpful because, let me ask, Commonwealth, are you objecting to me hearing this motion?
Well, I don't think there's any changed circumstances, so I am in that regard.
Okay.
So,
But the concept of me ruling on the motion in the sense of whether there's changed circumstances, you folks don't object to that?
no.
All right, go ahead.
So Judge, and there's actually another aspect to this that we're asking too that kind of go hand in hand.
Sure.
And that is that we're asking you also, I'm asking you to lift the restriction from the Superior Court, something I've never seen, where the Superior Court Justice said that she can't go to family court and do anything. It doesn't matter what family court says about custody or visitation. The experts that do this, that's their core function.
Where does the order say
The
that?
order here is that she has to stay away from the child and that she, regardless of any probate court orders. I can't point it to you this very second, but it is in writing in one of,
No,
yeah,
it's there.
okay.
I
So,
want to make sure that we're on the same starting point.
Right.
So we have a written motion on paper 73, which asks
Yes.
after the change of those other two.
right,
Orally, you're moving to vacate the order, so much of the order that says, let me see, have no contact, direct or indirect, with own child.
and only to the extent to say, subject to deferring to probate court. So subject to probate court orders, that's all.
Commonwealth,
Well, there's also a restraining order out there that has never been challenged at this point, so like.
but if, in other words, if I were to vacate that and make it, she's already, Ms. Fitzsimmons is already ordered to obey all orders, court orders.
I would leave that up to the board,
Okay.
as far as, I'd leave that to your discretion.
Okay, all right, so that's easy. I'm going to vacate so much of the pretrial conditions that requires no contact, indirect or direct with the child. And again, only because since the passage of a long time,
Yes.
we now know, because the Commonwealth provided dockets, that there is ongoing, at least a case has been opened related to the well-being of the child in the probate and family court. They're the experts. But I want to say that all that this initially did when it was entered was essentially ordering her to comply with the restraining order, which is a restraining order. It wasn't Judge McCarthy, it was the probate court judge that had granted.
The restraining order.
Right, okay. So I will vacate that.
Thank you, Mark.
And
And I could just tell you, just so you know, Judge, the motion for temporary orders has been filed, and the hearing on that is 4-2. So it's probably after this trial.
Can I ask something more out of intellectual curiosity? The Commonwealth in your motion provided the docket entries of the custody parenting case, but it didn't mention, those docket entries didn't mention the restraining order at all. Is that because it was taken out under a different docket number?
Correct, Your Honor.
Okay.
It's a separate case. I actually represent Ms. Fitzsimmons on the restraining order in family court, and my colleague, Ms. Hess, represents
Okay.
her
But
for
it's a
custody.
completely different docket number. That's why I
Right.
wasn't seeing it on the docket entries. All right, so.
And then that date, Judge, just so you know, 4/14 is for the restraining order, so.
All right, so I'm going to vacate that, and Mr. Boyd, just remind me, I need to, so you've docketed the orders, the order of pretrial condition at 74 and this GPS at 75. So I'll need to just change those, but let me wait until I decide the other issue. Let me hear you on that.
Thank you, Judge. So Ms. Fitzsimmons is preparing to be able to offer the family court a viable, good situation for whatever custody visitation she can get. And she needs to do that in advance of the 4-2 and the 4/14 hearings, so that she can go to family court and say, you know, I now have a home, I have a good, you know, that's the first question the family court judge is going to say. Well, if I give you something, Ms. Fitzsimmons, where are you going to be? Where's the baby? And we want her to be able to say, not that I'm at my family home in my high school bedroom. I want to be able, for her to be able to say, I have a wonderful townhouse, plenty of room, fenced-in yard, great situation, and I'm ready to go, Your Honor, and you know, we'll also proffer Dr. Zeisel's report that we have here for you, that this is a good thing for her, that this is something that is consistent with her very bright future, that's something that is appropriate. You know, this was a 4-month-old child who's now a year-old child, over a year old, and that this needs to happen for so many reasons, Your Honor, that I won't get into, but she needs to have a situation that's ready. And I think we have expert clinical evidence to show that in the present circumstance, she's ready for that. And we were asking the court to get on that bus and help her in this sense so that she's ready when this is over with. She's ready. She's in the best possible position she can be in to go to probate court just a week or two later with this in place. If it's not in place, God knows it's a nightmare scenario, Your Honor, because I'm sure you know the probate court dates are like, you know, they'll without batting an eye, they'll set like an August 8th, you know, and Ms. Fitzsimmons will be sitting here, you know, that's the point. So it's a very difficult scenario. We're just trying to get all of our ducks in a row as best we can, and this would be something that I don't think asks too much, and you know, she's agreeing, and you see in her letter and in my motion that she's saying, I don't want my lawyers to disturb any of this other stuff, you know, about house arrest and scram and, you know, the 2-hour notice, which we appreciate very much, to come see us. She doesn't want to disturb anything else. She just wants to change her address and live like a grown-up.
So can I ask something, Mr. Gradle, then? So there was much litigation prior to my involvement related to the alcohol testing, serum testing. And why isn't alcohol use mentioned at all in Dr. Zeisel's report? I think in either of his reports.
So, because it's something that, and I'll give you my real answer.
That's all I want.
It's something that was imposed on her to stick it to her, to punish her, Your Honor. There's no alcohol whatsoever in this case. There's no pattern of anything. It's a total red herring, and it never should have happened. And I am furious about it. It is absolutely beyond the pale that she was tortured with that scram device, Your Honor, and I'm furious about it, so I'm sorry, but talk about, you know, you got me on that one. I'm furious about it. It's baseless, is my answer, sorry.
So leaving aside your argument about whether it's baseless or not, I mean, I can tell you that I've read all of the impounded documents that the judge relied on in fashioning the order, and alcohol was mentioned by Ms. Fitzsimmons' own friends that were at that. So now let me say this.
At one party.
So my only point is that it's. So your position basically, actually, you're basically Dr. Zeisel didn't weigh in on it because he presumably doesn't think it's an issue.
And he's here, Judge, like I said, if you want to put him under oath and hear from him, I'm sure Dr. Zeisel will echo everything I'm saying about how there's no evidence, nothing's evident about any alcohol issue in terms of, you know, at a bachelorette party, a week or a few days earlier, whatever, fine. But as a basis for long-term, you know, monitoring is outrageous to me. And the only other thing in the record, Judge, talk about a reach, 2018 in like Myrtle Beach or something.
Yeah.
And that,
this isn't helpful.
And that was expunged.
I realize that I kind of opened the door.
I'm sorry. He's here, Judge. If you want to hear from him, you can get some more evidence on it. You know, the alcohol issue really is not.
Nice to see you.
Thank
How
you.
are you doing?
I've been well. How about you?
I've been excellent.
That's great.
I should say one last point, Judge, I think you missed. Ms. Fitzsimmons was breastfeeding at this time. She's not drinking. She doesn't have an alcohol problem. She's raising her baby. She's a wonderful mom. And this whole thing is infuriating. Sorry.
No, there's nothing to be sorry about, Mr. Grado. You're an advocate, and a good advocate for your client, and the judge asked you when you answered, and when the judge asked you, then you didn't want to hear the answer. So, I get it, so, but the point is, really, in all seriousness, the point is, you're not seeking to change the scram.
Right.
Right? And so, can you just tell me, how does the scram work? Is it random, or is it probation? Hi, how are you?
Good morning, Your Honor. Well, good afternoon.
Yeah, come on up. And you are again?
Alexander Hunt for probation.
I'm sorry?
Alexander Hunt.
Hi, okay. And do you want to swear her?
Would you raise your right hand? Do you solemnly swear to make true answers to such questions put to you by the court or upon its directions, so help you God?
Thank you.
Thank you.
I'm sorry, I don't think we've met before. Before this morning at the other hearing. Officer Hunt, are you supervising Ms. Fitzsimmons?
I'm not, Your Honor. It's
Who
P.O.
is-
Scrunchy in Salem.
Who is it?
P.O. Scrunchy.
How do you spell that?
SCRENCI.
All right, another officer that I'm not familiar with. So what is the report back? Has she been in compliance?
She has, Your Honor. She was 7 minutes late to curfew on March 10th, but she had informed Elmo ahead of time, and points show that she was stuck in traffic coming back from an attorney's appointment. She also missed 2 scram tests, but then passed the immediate on-demand test. So she's passed all her scram tests.
Okay.
So other than those minor incidences, she's been in full compliance.
And the scram, how does it work, or how is it working in this case? Are they random?
They are random.
Okay, so what happens? Does something go off on the device or something?
That's correct, Your Honor. A noise alerts her that a test needs to be taken, and then she has to take the test.
Okay, is that something that, again, this is more intellectual curiosity, because I haven't really had the opportunity to learn about how exactly the scram device works, but I think it's important for me to know, because it's one of the more significant parts of the pre-proclamation work. But what happens for the notification? Is it the GPS monitoring bracelet that goes off that tells?
Those are separate, Your Honor,
They're
but
separate.
Elmo supervises both of those.
Okay, so what happens, how does Ms. Fitzsimmons know that it's time to do a scram test?
It alerts her, a noise goes off.
So, and what is this device? The device is a breathalyzer or something?
Essentially, yes. Yes, Your Honor. There's a straw that she has to blow into. It takes her picture so it knows it's her. And that's how, and then via like Wi-Fi, essentially.
So does that mean that she has to have that with her when?
At all times.
Okay, so when she leaves to go to doctor's appointments?
Yeah, so Judge, I got it right here. It beeps from 7 a.m. to 11 p.m. all the time, and she blows into it, and it took her months to be able to blow into it without a lot of pain, and she can do it now because her rib is healing up. Her rib was blown apart in this shooting, and she can breathe now, and she can do it. And it gets on her from 7 in the morning till 11 at night. And it also has a GPS component to it as well. So she's on double GPS.
Roughly, I know it's random, how many times a week do you know that it asks? Is there?
I'm not positive of Ms. Fitzsimmons, but I believe probably does around 50 tests every 2 weeks.
Really?
I wish she has many random tests a day, as ordered.
Judge, I think it's, for Ms. Fitzsimmons, I think it's about 4 times a day it goes on.
And cast for flying colors as far as we.
Correct, Your Honor.
Good, good. All right, Mr. Brady, is there anything else anything else on Officer Hunt that I should know about her performance on pretrial conditions?
No, Your Honor, she's been in full compliance and in communication with probation.
Okay. All right.
So she's been a great probationer, Judge. I appreciate you inquiring about that on your own. And, you know, it's just a step in the right direction for her. It's not a lot to ask. It's something that I know based on my interactions with her over the last 9, 10 months, that, you know, she's very motivated to not do anything in contravention of the court.
So what is, actually, I'm not going to ask you this because I know what the answer is. Mr. Gubitsch, reside with Lauren and William Page. And, go ahead.
Well, I can't speak for Judge McCarthy, but I was there. This is not something that I agreed to, I encouraged or anything like that.
Right.
It sounded like that because of the situation in its entirety, including a statement from her high school friend that she's had an alcohol problem and an aggression problem since then.
I saw it.
That the judge thought it was appropriate for the mother to monitor her. So she made sure she does everything, including making sure there's no weapons, no dangerous weapons, nothing in the house that would be considered dangerous. And so that is what Lauren Page, the mother, had sworn that she would do. And I think that answers your question as best as I can answer it.
Okay, and tell me about your objection.
My objection is, we're all glad she's doing well, but why are we going to mess with it at this point? We have a trial in 10 days, which is going to be a very stressful time in her life, I'm sure, that we're coming upon. There have been no change in circumstances to suggest that, no real change in circumstances to suggest that this is an appropriate reason to change anything or a time to change anything. I think all that could happen here is we mess something up and it messes with the trial. Or she hurts herself or she hurts someone else. That's what this is about. These conditions were put in place for a reason. I would suggest they were ultimately fair. I just don't understand why, if in her letter to the court,
By the way, Mr. Green, did she sign that?
Yes.
Okay.
her primary reason for this request is in preparation for my interpretation of my child. We're talking 2 weeks. 2 weeks from the time of today to basically, we could be finished if it's a streamlined trial. If it's not broke, let's not fix it.
Well, but from her perspective, it is broken. That's what she
Sure.
said.
In my perspective, and from the unbiased, really, look at this, it's not broke. She's doing everything the court has asked her to do, which she should be doing. And so, what's the changed circumstances at this point?
Mr. Grado, the changed circumstances.
I point to Dr. Zeisel's report, her letter, the passage of time, the fact that we're in a trial posture, and sort of maybe why don't we analogize it to, when someone asks you to remand a guy from Pittsfield to Essex County House. It's like counsel for the column is answering my own question, which is it's a stressful time because she's in a difficult situation and it's hard for her to prepare. If she has her own home, it's much easier. She can come and go. She has the whole place. She can focus on other things when she wants. It's just I don't want to make too much of it, Judge. She's just going to go to an appropriate home, and it helps her in her family court efforts. That like I said, I don't want to get pushed off months and months if we're not ready on that occasion. So
I'm sorry, about what?
I'm alluding to what I mentioned earlier, Your Honor, about how on the 2nd and the 14th of April, we're going to be in family court, and I want to be able to say that she's been in her house for a couple of weeks. She has a great situation. She's been setting it up, and it'll just take a lot of it'll uncap the tea kettle, and a lot of steam will escape here if she can just kind of be in her own place.
Right, but that wouldn't be grounds that would support my revising or modifying those two conditions. But I can say that I think the teachings of the SJC's cases under 58A often are that the passage of time can be a changed circumstance. And here, there is arguably a changed circumstance because Dr. Zeisel has said that her mental health has improved significantly, because my memory is that in the first report that Dr. Zeisel wrote that's in the file that's impounded, he did imply or mention that she didn't contest that she had been suffering from mental health concerns at the time.
Yes.
And in do see, I guess the long story short is I do see sufficient change in circumstances. The question is whether, whether the supervision by her parents is something that I would change on this record. And so does Ms. Fitzsimmons have an address in mind?
Yes, Judge, it's all set, even the lease is signed.
And,
We would allow this.
when would she move?
As soon as you're ready, Judge. She has custody of the place. Whatever would work, she's ready to go.
And
And it's in Essex County. I can certainly give you the address, obviously.
right, and she's amenable to having probation inspect the place
Absolutely.
prior to her move? Yes?
Yeah, oh, absolutely. I think that's a
And
motion.
how
Judge,
about if I were to order visits to
No objection.
to ensure compliance with the no weapons and
Certainly.
et cetera?
No objection.
Sorry, Officer Hunt again, come back up. So can you tell me, if I were to order some kind of a visit by probation before the defendant were to move into the location to make sure that it is a place that, at least from what is observed, that doesn't have any weapons, to see what the words have to work. No weapons brought into home, so weapons being pretty broad. Is that something that the probation department can do?
Absolutely, Your Honor.
And how about, I know that home visits happen all the time when someone is on post-trial probation. Is it something that you folks see occasionally, at least on pre-trial?
I'm aware of one case we've had where we have done it, so I believe it's possible, but I would like to double check with the supervisor. As for the home visit, that could be done, the initial home visit to check, we could do that by the end.
Is Officer Scrunchy available for, at least maybe even for you to communicate with about that aspect?
Yeah, I can contact her right now.
So it seems to me that, and again, I don't want to go back and forth on this. I read all of what the original judge had before her, all of these orders were well supported. They were orders that I would have issued at the time. They're orders that a single justice affirmed. They're orders that the SJC affirmed. I don't want to relitigate that, but I also believe that there's sufficient grounds to consider allowing the move and allowing the termination of the supervision, I guess, or the residing with the parents, so long as the probation department could monitor, and it would be by surprise monitoring. So, Officer Hunt, I don't know if you heard that. So I'd want these visits to be a surprise.
That's no problem, Your Honor. I also just spoke with my supervisor, and she said as long as it's a court order, we can do it.
Either side want to be heard any further?
Judge, I just should say that her PO is aware of this request and it's been discussed. And, you know, I shouldn't say that she agrees with it. I just say that she's fine with it in the sense that whatever the court order, she's happy to implement.
Anything else, Kamala? I'm going to allow the change, subject to an inspection by the probation department
Smile. She's almost smiling.
prior to.
That's a smile. You see you, Kelsey.
Ms. Fitzsimmons' move.
Wow.
Physical move into the new place. And the inspection will be for weapons and also alcohol. You may as
Oh,
well,
damn.
look for that.
She's smiling.
Subject to.
Bradle got some things done today. He did.
random
See, some
inspections by the.
he Radel is as strong as he needs to be. That's what I'm gonna say. The
It makes
Mrs.
sense at this
1088
point is for me, so
doing a good job.
It would also mean that the GPS supervision conditions would need to be changed. I think it makes sense, Officer Hunt and counsel, for me to just issue a new order, and rather than write on this, I would carry.
She's
over
trying not
all
to
of the
smile now.
orders,
Look.
No, you know what, I don't think it's necessary.
Look at that.
Do you have, do you want to come to the sidebar on the address? Or is it something that you can provide?
I just provided it to probation, Judge. and-
Yeah, but I need to keep, everybody come on over to the sidebar, please.
Felt the same way the other day in court when I was there for Kelsey, and I got the message from my lawyer that the motion to dismiss went through. I started smiling. I was like, I can't be smiling here. This is weird. I was like so excited. Kelsey looks like that right now. She's very trying to hold in the smile. Gotta think this is almost over. Jump off and go walk some dogs. If I'm gonna let this run, I'll monitor it remotely on my phone and shut down the stream from my phone. I guess I'm gonna come back this afternoon and go over it, over what this hearing got accomplished, because a lot did get accomplished already. Very good news for Kelsey Fitzsimmons. And maybe review some of that video from court today. There was some stuff happening outside of court beforehand. I wonder if there'll be something after. We'll see. Check out JFK show off if you can't wait, but I'll review it this afternoon when I get back as well. So look for an afternoon stream today too. I'll see you in a few.
quiet, please.
So, I really, I have to. All right, so I am going to allow that modification for the reasons that I've already described, both in open court and at sidebar. I need to just write it up. We'll impound the new address. I'd ask all counsel, as I said at sidebar, to continue to keep in mind that we want our jury pool to be as made up of as indifferent of a group of folks as we can, and that's what my expectation is going forward. All right, so we can change that, which I'll do. Anything else, folks?
I filed another final certificate of compliance, so I'm expecting any moment council's reciprocal discovery.
So, when you say, is that something, so is it something that I need to weigh in on, or are you just making a record?
Just making a record.
I'm sorry, I missed it, Judge.
Mr. Gubertosi reported that he filed a final certificate of compliance under Rule 14,
Sure.
and that he's hopeful that.
I think we're there. There's a couple little things that I'm not going to make any sure.
All right,
We
so.
can work on that. Thank you.
All right, but also I need, and I appreciate the sending of the joint witness slash prominent names list, but there's a bunch of names on there that don't have towns or cities associated with them, and.
Yes, as counsel said at sidebar, there's a safety concern in this case based on things that have happened, so I will get those in court before the trial.
All right, so, but how do we handle, I want to provide enough information for the potential jurors to look at that list and say whether they know a person or not.
We'll get a town.
Okay, and then, but are you suggesting that that be impounded?
No.
Okay. So, all right, so the missing, you folks will get, will run down the missing cities and towns of the folks that don't have them on that list.
I have them, and I'll supply them to the court.
And Mr. Brado, given how close we are to the trial, and with Ahuli, when you said that something to the effect that there was a couple of little things that perhaps, the bottom line is, are you prepared now to disclose whatever it is that you're required to
Yes.
disclose?
Yes.
And I'd ask you to do that as soon as possible so we can keep the trial on schedule.
Sure.
All right, and let me just see if there's anything else on this, Mr. Wayne. So, in a perfect world, we reconvene to talk about the juror questionnaire, which we could. So are you folks, would you folks be available Monday afternoon to, by then I've disseminated the draft of the juror questionnaire, that's all that we would go over. And you, Ian, hold on, sorry. Ian, you can appear by Zoom if that would be easier for you folks.
So if we're only doing the questionnaire, yes. That's fine.
Available, yes.
All right, so in other words, no surprises from the Commonwealth.
No, I'm not expecting any.
I can't, we'll all be surprised if there were surprises. All right, so I'll, that means I have some work to do and get that out to you. Mr. Roy, you have their email addresses?
Yeah.
Judge, did you say 2 o'clock Monday? 2 o'clock.
Whatever Mr. Roy said. So, all right, so I need to, I'm going to step off, I need to write up the change conditions, which I will do if you want to just hold tight.
Thank you.
2 p.m. This Monday is the 16th. All right. All right, so we'll stay on recess.